I'm going to take you all through the next third, roughly, of the report. And the first thing I'm going to talk about is the controller. I suppose at some stage had some thoughts about whether the controller was properly named and whether he should be named something else. Most of you will be aware that the controller is currently called Controller of Patents, Designs and Trademarks, but we felt that that didn't fully reflect the scope of the duties and responsibilities of the controller, and in particular it didn't address the fact that the controller has a role, for example, in relation to copyright. And I suppose the history of the title of the controller is that in 1927, when we had the industrial and commercial property legislation, he was known as the controller of industrial and commercial property. Then with the Patents Act in 1964, the title changed to the Controller of Patents, Designs and Trademarks. So I suppose you could say we're going back in time a bit, and we're now proposing that the controller's title should be changed to the Controller of Intellectual Property. So as you can see there, somewhat similar to what he was called in 1927. So why did we consider this was something important that we should devote some time and attention to? And again, as I say, one of the large parts of the function of the controller is the day-to-day administration of copyright. So we felt that should somehow be reflected in the title. Because while I suppose we were always looking at what's happening elsewhere in the world, and in many other countries, the title is a more inclusive title than perhaps the one that we have. And I suppose probably the best example of that is the World Intellectual Property Organization, which uses the wording intellectual property as opposed to any other wording. So therefore, as I say, the proposed new title that we have for the controller is the Controller of Intellectual Property. That would necessitate a change in the title of the office as well, and we're proposing for that the Office of Controller of Intellectual Property. And I suppose again, the reasons why we're doing that is we think it's more accurate, and it's more inclusive, and it's more appropriate, and it also allows more flexibility for other functions to be within the controller's remit, and the title to still reflect the fact that the controller has those functions. Another thing that exercised our minds is the fact that setting out rights and obligations in legislation is really only one part of the picture, because there comes a time when someone may need or want to enforce those rights. So it's very important that there is access to justice there, and access to justice, I suppose, at a cost that those affected can afford. And I suppose I'm conscious, being a practitioner, that certainly sometimes justice is only open to those with a certain amount of money. So we looked at the court system, and one of the conclusions we came to that we would recommend the establishment of special intellectual property jurisdiction in the district court and the circuit court. Now, I suppose to do that, we had to go back to first principles as such, because we wanted to ensure that the jurisdiction that we gave to those courts wasn't just confined to copyright, because from a practical point of view it's often very difficult to break out disputes into just one area of intellectual property, and what we didn't want to happen was if there was a dispute that encompassed more than copyright, that you ended up with two different streams of where somebody had to go to get a remedy. So to deal with this particular issue, we provided a definition of intellectual property claims, and you'll see that in the draft bill that we prepared. And as I say, it's important to note that what we're looking at here is jurisdiction for the district and circuit court, not just for copyright, but also for all aspects of intellectual property that fall within the definition. So the first court that we looked at was the district court. And the district court already has a role to play, particularly in relation to copyright, because it does have some powers, for example, under the Copyright and Related Rights Act, and indeed other jurisdictions. other pieces of legislation in connection with powers of search and seizure. So the whole area of intellectual property isn't totally unknown to the district court. So I suppose we started from that. And then we looked at the fact that the district court currently has a small claims procedure, and we wondered if we could do something with that to assist in the enforcement of IP rights. Now, the difficulty with the small claims procedure is that there's a financial limit of €2,000. So we felt if we restricted the jurisdiction to that, it probably wouldn't be particularly attractive, or there wouldn't be a great deal of claims that would be able to benefit for it. So instead of that, we took the view that small claims that involve intellectual property matters should be entitled to be brought as small claims up to the value of the jurisdiction of the district court, which is currently at 15,000. Then we looked at the circuit court, and we have recommended that there be a specialist intellectual property court of the circuit court. And again, that will not be just for copyright claims, it will be for all civil IP claims. And again, that will be up to the monetary jurisdiction of the circuit court, which is currently at €75,000. The aspect of, I suppose, the powers and duties of the controller that we looked at was the circumstances where there can be a right of appeal from a decision of the controller. And I suppose in submissions it was suggested to us that perhaps in some circumstances it might be appropriate that when there's an appeal, there's a complete rehearing and not just an appeal on a point of law. So we then provided for the circuit court to have jurisdiction to hear appeals from decisions of the controller, and that would be a full rehearing, not just an appeal on a point of law. Okay, coming on to the issue of rights owners and how we would, I suppose, enhance their rights. And I suppose I'll start off somewhat with a negative, because there were a number of things that we received submissions on that we decided we wouldn't make any changes to. But rest assured, we did good reasons why we didn't do that. We did receive submissions suggesting that we put in place a registration procedure for copyright, but we took the view that we were precluded by the Berne Convention from doing that. There were also suggestions that perhaps we should amend the term of copyright protection, but again we felt we were precluded by EU law from doing that. Other suggestions were that there should be something that had to be done formally to claim copyright. Again, we rejected that idea, something that we were precluded from doing. Also, we received suggestions that perhaps we amend the definition of originality or the definition of authors. But again, we felt that we were precluded from dealing or amending those in any way. Now, as the Minister spoke earlier, there's now an EU consultation process looking at the whole area of copyright. So I suppose anyone who still feels strongly about those particular areas, that might be an avenue to explore. Another area where we felt we were not in a position to do anything because of developments that were taking place at EU level is the whole area of levies. So we didn't make any recommendations in that regard either. So what did we do? Well, one of the things, and again it's one of these things if you're looking for something to put yourself to sleep, there were provisions, or there are provisions currently, which could be interpreted as meaning that if you have an unpublished work, because of the way particular sections of the Copyright and Related Rights Act is worded, it could be interpreted as meaning that you could end up with perpetual copyright. And I don't think that was ever something that was intended. So with playing around with the wording of the relevant sections, we made some suggested amendments there. The other thing that we looked at were remedies, and that obviously tied in with the whole concept of the court system as well. We came to the conclusion that we didn't need to add in any more criminal remedies, but we did look at the civil remedies. And one of the things we looked at, and we did receive, I suppose, a lot of submissions in this regard, I suppose one of the things that were coming out of those submissions was really that there should be proportionate and graduated remedies, and particularly in the context of damages. So we took that on board, whereby at one end of the scale, where there's unintentional breaches, they won't be met with a significant award of damages, but at the other end of the scale, where you've got more serious breaches, we've suggested that those sorts of circumstances could give rise to restitutionary, exemplary, or even punitive damages. We also looked at the existing provisions in the copyright legislation, and we looked at the provisions that deal with infringement of copyright. We looked at those that deal with infringement of performers' property rights, performers' rights in general, and also recording rights. And there wasn't always consistency between all of the provisions. So one of the things we tried to do in our suggested bill was to come up with some consistency between all of those provisions. Another area that we looked at was this area of technological protection measures, or TPMs as you'll see them called in subsequent slides. And there were a number of things which we felt we needed to tidy up in our bill in connection with that. Firstly, from submissions that we received, there was a perception that the current legislation only gave remedies in connection with the technological protection measures to licensees rather than to right owners. And again, this was a situation where we didn't think that was intended, so we tidied up the legislation to make sure that that isn't the case. We also made the act of circumvention something that's actionable as if it's an infringement. And we also provided that if there are any technological protection measures which prevent somebody from exercising an exception that's contained in the copyright legislation, we provided a remedy for that as well. Now, photographers was something that, again, as a result of the submissions, they do have a significant number of problems which they need to overcome. And I suppose a great deal of those problems arise out of the fact of the ease of reproduction of digital photographs. So I suppose we had two things in mind when we were looking at the situation of the photographers, which is how to prevent reproductions that infringe copyright and how to provide proper remedies. And I think before we can talk about that further, we need to talk about this concept of metadata. And I suppose just to explain what we mean by metadata. And in reality, I suppose it's quite simple. It's data about data. And I suppose if you think of the simplest example of that, it's probably a library card catalogue. And that will give you information about a particular book. It will tell you who the author is, it will tell you the title, the publisher, the publication date. And that essentially is metadata about a book. But then when you get into photographs, I suppose things become a little bit more complex. So I'm showing you a photograph there, and I suppose if you just look at that, that's a photograph, it could be any sort of a photograph really. And then I'm going to show you here the metadata about a photograph. And you'll see again, not dissimilar to the book catalogue. It gives you all sorts of information about the camera, the exposure, the date and the time the photograph was taken, when it was modified. So there's a lot of information there, and one of the messages that was coming across was loud and clear that infringing copies of photographs, this information is often tampered with or it's often removed. So that's what we had to address in our draft bill. I suppose the first thing we did is we put in a definition of metadata, and then we amended the legislation so that there's no doubt that metadata is included in the definition of a work protected by copyright. And we also provided that the removal of the metadata would amount to an infringing adaptation of a particular work, to just strengthen the provisions for photographers there. And I will now hand you over to Steve, who will take us through the final part.